Item number 4.
Fine. Yes, Mr. Banerjee, you are free now?
Yes, sir. Thank you, Lord.
Yeah. Yes.
Sir, kindly first three, three sections I want to show one of the Arbitration Act, and I think one of that really holds one of the key to one of this problem which we have. One of section 11, with regard to one of appointment of the initial arbitrators, when one of the procedure fails in an arbitration agreement, the jurisdiction is given to the High Court and the Supreme Court,
Yes.
or Supreme Court typically.
Yes.
In spite of there being a definition of court which is existing in 21E, section 11 kindly come to section 11, it says
Yes.
11 for proviso
Provided that.
provided appointment made on application by the Supreme Court, international, or by the High Court. Well, appointment shall be made. Let's see, section 11(4), appointment shall be made on an application of the party by the arbitration institution, either by the Supreme Court case of international or by the High Court case of arbitration, other than international commercial arbitration case may be. And then, also see 11(6), which is what we are concerned with generally, where under an appointment procedure agreed upon by the parties, party fails to act as required under the procedure, or the parties or the two appointed arbiters fail to reach an agreement expected of them under the procedure, or a person including an institution fails to perform any function entrusted to him or it under that procedure, the appointment shall be made on an application of the party by the arbitral institution designated Supreme Court or by the High Court case of arbitration other than the international commercial as case may be taken necessary measures. So my first submission is that when under section 11 the court is specifically designated with regard to appointment of an arbitrator,
Yes.
in spite of there being a definition under section 21E,
Yes.
it shows what the legislature has intended. Because section 11 appointment procedure is different, and section 29A is a different procedure. Because section 29A is not only a question of substitution when the occasion arises, but it's also a question of extension of time, as well as the question of imposition of exemplary penal cost and all that is there so far as section 29A is concerned. So my first submission is when the meaning in the statute and when the sections in the statute are clear, we will really have to go with the statute itself.
Okay.
Now, I'm taking a leaf from the Learned Advocate General's arguments and saying contextual interpretation, that's what he said. But here, contextual interpretation has nothing to do in this matter, because when the 29A was introduced, then section 11 also existed, as well as section 21E existed. And nothing stopped the legislation then from then saying that court here would mean the High Court or the Supreme Court, as the case may be. Now, I've shown, I'll also show why the Delhi High Court judgment, perhaps with the greatest respect to Justice Jyoti Singh, the judgment will not apply because the court really got influenced with the question of appointment of arbitrators by the Supreme Court in international commercial arbitration. Now, turn to section 29A. Excuse me.
Yes.
The award, section 29A(1), the award in matters other than international commercial arbitration shall be made by the arbitral tribunal within the period of 12 months from the date of completion of pleading under subsection 4 of section 23. Then, provided that the award in the matter of international commercial arbitration may be made as expeditiously as possible, and endeavor may be made to dispose of the matter within a period of 12 months from the date of completion of proceedings under section 4 of section 23. Similar, so one says award in matters other than international commercial arbitration. Similar, international commercial arbitration, my lord, is freed from the rigors of the time period. So, my lord, they will never have to come, my lord, in an international commercial arbitration to, my lord, a 29A court to have, my lord, substitution, my lord, of any arbitrator. Then, my lord, kindly sees subsection 4.
Yes.
If the award is not made within the period specified in subsection 1 or the extended period specified in subsection 3, the mandate of the arbitrator shall terminate unless the court has, so here, my lord, no, unless, my lord, it would have said unless the High Court has or the Honorable Supreme Court has. Supreme Court, my lord, obviously is not considered, as the case may be. That is not put. Either prior to or after the expiry of the period so specified, extend the period. Provided that while extending the period under this subsection, if the court finds that the proceedings have been delayed for the reasons attributable to the arbitral tribunal, then it may order reduction of fees by the arbitrator not exceeding 5% for each month of such delay, provided further that where an application of subsection 5 is pending, the mandate of the arbitrator shall continue till the disposal of said application. Then, my lord, 6 is, my lord, what comes in. While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all of the arbitrators. And if one or all of the arbitrators substituted, the arbitral proceedings shall continue from stage already reached on basis of evidence and material already on record in the arbitration. Well, let's see now, shall be open to the court to substitute. Now, if my lord also looks at another provision, my lord, section 34.
Yes.
Well, 34, my lord, is with regard to setting aside, as we know.
Yes.
And there also, my lord, we find recourse to a 34.1, recourse to a court against an arbitral award may be made only by an application for setting aside said award in accordance with subsection 2 and subsection 3. An arbitral tribunal may be set aside, arbitral award may be set aside by the court only if. Now, my lord, if I just, my lord, put my argument, my lord, in a question form. My lord, today, I'm sorry, my lord, there is no sanctity in saying because the High Court has appointed an arbitrator, my lord, a principal civil court will not have jurisdiction
To extend.
to substitute or extend. Because otherwise, my lord, the same logic would have consequentially followed and said, sorry, the Supreme Court has appointed an arbitrator, how could you set aside his award?
Yes.
So it is not a question of, my lord, giving any sanctity to, my lord, the fact of the original appointing authority. The legislature intended that the original appointing authority in a domestic arbitration would be the High Court, in an international commercial arbitration would be the Honorable Supreme Court. Thereafter, any further proceedings will have to be in terms of section 2(1)(e), which defines the court. So my submission is, my lord, we can't have a special court to be the High Court or the Supreme Court to be created for the purpose of a section 29A application. Because it is not only substitution, because it deals with a whole lot of other situations. Because, my lord, the logic which was applied, saying, my lord, if the High Court appoints, how can the district judge, honorable district judge, if the Supreme Court is not concerned, High Court appoints, how can you? But that would mean, and which, my lord, I think, my lord, asked a question, and, my lord, I respectfully submit, my lord, very pertinent question, my lord, in that sense, my lord, if I may say so, my lord, saying that in our case, my lord, it is without intervention of court. It is without intervention of, my lord, the High Court that, my lord, arbitrators have been appointed. My learned friend's submission would mean that even if parties have appointed an arbitrator by their consent, by a section 29A, I will have to go to the High Court. Then, my lord, to have an extension. So it is not that you can describe one situation in your argument to say what happens if the arbitrator is appointed by the High Court. Because the other answer would be what happens if the High Court has not appointed the arbitrator, which is, my lord, in our case. If the parties have nominated, my lord, appointed an arbitrator. And it is also no argument to say that the principal civil court today cannot substitute an arbitrator when he has the effect of even setting aside the award which has been passed by any appointing authority.
That's the only troubling point for the court, Mr. Banerjee, regard substitution, appointment, or of replacing the entire arbitrators, because to draw from analogy from Section 11, that's the only thing that you have to satisfy this court.
I fully appreciate, but kindly what I'm saying is kindly also appreciate that it is not necessary that everyone has to go to the High Court. 11.6 says when the procedure fails.
Yes.
It's a failing provision which the legislature has specifically considered and said High Court and the Honorable Supreme Court. Because nothing stopped the legislature to have also said that a 29A or a 14 application would also be made there. I'm just trying to break this argument which has been made, linking 29A with the appointing authority.
Right. That's what troubles the court, yes.
Because the appointing authority may not be the High Court also. In a case where the High Court is appointed, I understand an argument means if the High Court is appointed an arbitrator, how can it be replaced under Section 29A? But similarly, a counter argument, a mirror argument would be what happens if the High Court has not appointed the arbitrator? Then where's the question, if I may put my argument?
The High Court coming in at all?
Sorry,
What was the question, the High Court coming in at all, at any juncture?
Yes. Correct. This I found to be with the greatest respect to the learned Advocate General and to all the judgments which are against me, that that logic fails. When you question a situation, when you propose a theory, it has to be good for all situations. Otherwise, the theory cannot be proposed because you are actually taking the definition of court out of Section 29A and out of Section 2(1) subsection E and imposing a definition in Section 11 to that of the court. This, I find, with the greatest respect, I find, it's really twisting the logic of not defining court there. Because you're superimposing Section 11 definition of court on Section 29A. Why not Section 34? Why not Section 14? And I'll show that's why Nimet resources becomes very important. In fact, the Supreme Court, I'll show a line where Supreme Court also spoke of substitution there in the Section 14 context. And looks at Section 2(1)E, the definition kindly see, court means in the case of an arbitration other than an international commercial arbitration, the principal civil court of original jurisdiction in a district.
Yes.
In a district and includes the High Court in exercise of its ordinary original civil jurisdiction. So one might also get very upset that the district court is also in that sense includes High Court exercising its ordinary original civil jurisdiction. But that's the intent of the legislation. Yes. Includes the High Court in exercise the ordinary original civil, having jurisdiction to decide the question forming the subject matter of the arbitration if the same had been the subject of suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. And then II, in the case of international commercial arbitration, High Court in exercise of its ordinary original civil jurisdiction having jurisdiction to decide the questions forming the subject matter of arbitration if the same had been the subject of suit, and in other cases, kindly see how particular, and in other cases the High Court having jurisdiction to hear appeals from decrees of courts subordinate to that High Court. So, my lord, jurisdiction of courts, my lord, is specifically, my lord, given to district court, principal civil court of original jurisdiction in a district, which includes the High Court, for a domestic arbitration, and my lord, in international commercial arbitration, it confers jurisdiction to both a High Court exercising ordinary original as well as a High Court not exercising ordinary original. So that is how, my lord, court precisely defined, and, my lord, context of, my lord, imposition, my lord, or, my lord, creation of jurisdiction, my lord, is given in the legislature.
Okay.
So, my first submission, therefore, my lord, is looking at, my lord, section 21E, section 11(6), and, my lord, section 29A, also section 34.
To get the meaning of court.
Yes. So 21E, my lord, is 29A, wherever, my lord, court otherwise is mentioned. 29A, my lord, 34.
Yes.
36. And 11(6), my lord, is a jurisdiction which is carved out for the High Court and the Honorable Supreme Court when the appointment procedure fails, and specifically conferred. So we should not try and superimpose this definition in 11(6) on, my lord, a section 29A. Otherwise, my lord, the legislature itself would have said it. There's no reason why, my lord, it would have left to, my lord, then an interpretation of, my lord, court. If, my lord, looks at, my lord, the Delhi High Court judgment, my lord, which my learned friend has relied on.
Yes.
And, my lord, I straight away just want to, my lord, show why, my lord, in my submission, because it seems, my lord, Delhi High Court also followed, my lord, Gujarat and Bombay. I found, my lord, greatest respect, my lord, to the learned judges, my lord. Gujarat and Bombay, Gujarat really, my lord, didn't say much on this issue, but they seem to have, my lord, followed. My lord, this is my lord, Justice Jyoti Singh, my lord, in DDA versus Tarachand Sumit Construction. My lord, we have seen, my lord, what had happened, my lord. They had taken away, my lord, the section 29A because, my lord, the pecuniary jurisdiction was less. Then, my lord, they made an application for recalling of that order, and in that context, my lord, the learned judge, my lord, was deciding this issue. Now, kindly come to, my lord, paragraph 11. I'm sorry, my lord, I hope, my lord, has the judgment.
This Tarachand Sumit, right? I mean, the same judgment
yes,
in
yes,
India.
Yes. Yes, my lord, what they relied upon. I'm showing, my lord, this is, my lord, really the sheet anchored, my lord, of their case, my lord, as we, my lord, say, my lord, when.
Para?
My lord, paragraph 11, kindly, my lord, first see.
Okay. Yes. Learned Counsel.
Learned Counsel relies on a judgment of the Gujarat High Court in the case of Nilesh Ramanbhai Patel, such and such, and as also the Bombay High Court in the case of Kabra Installations and Services SA. So these are, my lord, the two judgments which are relied upon, and, my lord, also, my lord, relied upon by them. Then, my lord, kindly come to 21, para 21. The main controversy that arises for consideration in the present application is whether the petition, as filed earlier and subsequently withdrawn by the petitioner, is at all maintainable in this court, or the power to extend the mandate of the arbitrator lies with the Civil Code of Original Jurisdiction in terms of definition of the term court in section 21E of the Act. In order to decide the said issue, it is important to take note of certain provisions of the Arbitration Conciliation Act. The 21E is noticed. 29A, learned judge, my lord, sees, my lord, from subsection 3.
Yes.
Then, my lord, kindly come to paragraph 22.
Yes.
Section 11(5) and 11(6) of the Act relate to appointment of arbitrators by the High Court or the Supreme Court, as the case may be, and details the procedure to do so therein. In case of international commercial arbitration, the power of appointment is vested only with the Supreme Court, while in the other arbitration, High Court has the power to make appointment in terms of section 5 or 6 of the CAT.
Yes.
Section 29A came to be inserted in the statute by the Amending Act 3 of 2016 with effect from 23rd October 2015. The section has been extracted above. Perusal of the section indicate that it provides for timelines with which the arbitration has to be made, including sunsets. Then, my lord, I'm sorry, kindly come to paragraph, my lord, 25.
Yes.
Section 29A of the Core Act incorporates an important provision by way of subsection 6, and which in my opinion is relevant for deciding the controversy in present case. This provision confers on the court a significant power of substituting all or any of the arbitrators while extending the mandate under subsection 4 if the need arises. In case such substitution is made by the court, the arbitral proceeding shall continue from the stage already reached and on the basis of evidence material already collected. Therefore, when it comes to the time limits for passing the award or the extension of mandate, the section is a complete code in itself. Then 26, when one looks at the definition term court under section 218 of the Act, clear that in case of international commercial arbitration, the kind of similar, clear that in case of international commercial arbitration, court would mean the High Court in excess of the ordinary jurisdiction having jurisdiction to decide the questions forming subject matter arbitration, same had been subject to suit, or the High Court having jurisdiction to hear appeals of courts. Case of other than international commercial, it would be the principal civil court of original jurisdiction district, includes the High Court in excess of ordinary jurisdiction. Then, my lord, 27. If the definition of the term court is looked into, no doubt the contention of the respondent seems plausible that the power to extend the mandate of arbitrator would lie with the principal civil court. However, on a careful analysis, in my opinion, this interpretation would lead to complications. I'm not, I'm sorry, and perhaps in the teeth of the powers of the courts under section 11. Because the question that poses a challenge is whether the term court can be interpreted differently in the context of section 20. In my view, subsection 1 of section 2 of the Act itself gives the power as it begins with the expression in this part unless the context otherwise requires. Now, my lord, I'm sorry, but my lord, this is with the greatest of respect. I'm sorry, I'll just read one more paragraph, then my lord, come to this. Kindly see, my lord, paragraph 28. 28, my lord, at the middle of this, the complexity, my lord, sees. The complexity, however, arises by virtue of the power of court to substitute arbitrator while extending the mandate, and this complication is of a higher degree if the earlier arbitrator has been appointed by the High Court or the Supreme Court.
Yeah.
Coupled with this, the one cannot lose sight of the fact that legislation wisdom has conferred the powers of appointment of an arbitrator only on the High Court or the Supreme Court, depending on the nature of arbitration, and as and when the power is invoked by either the parties. There may be many cases in which, while exercising the mandate of the arbitrators, court may be of the view for some valid reason arbitrator required to be substituted, which case the court may exercise power and substitute. Then, number 29 also very important. In case a petition of section 29A of the Act is filed before the principal civil court for extension of mandate and the occasion for substitution arises, then the principal civil court will be called upon to exercise the powers of substituting the arbitrator. In a given case, the arbitrator has been being substituted would be arbitrator who had been appointed by the Supreme Court or the High Court. I'm sorry, my lord, this would lead to a situation where conflict would arise in the past. No. My lord, three things, my lord, the learned judge, my lord, with the greatest respect, my lord, fails to notice.
Yes.
First is all appointments under section 11, 5 and 6.
Yes.
Or rather, all appointments are not under section 11, 5 and 6. That's my lord, the first submission.
Yes.
Therefore, linking appointments under section 11, 5 and 6 with a situation in section 29A is perhaps logically, my lord, not sustainable. That can't be the logic. Secondly, my lord, the learned court seems to have been swayed by the fact that, my lord, there will be an appointment, my lord, by the Honorable Supreme Court.
Yes.
My lord, again, this is, my lord, not correct because, my lord, section 29A, it is not applicable to, my lord, in international commercial arbitration. Thirdly, my lord, I say that, my lord, the learned judge fails to consider a situation where indeed the appointment is outside the scope of Section 11.
Yes.
Because, my lord, my submission is when, like, my lord, I said, I'm sorry, my lord, I'm just repeating this one sentence, I'm so sorry, that, my lord, when you logically propose a theory, then it has to cover all situations. Otherwise, you can't take one situation to interpret definition of court. That would lead, my lord, to a very dangerous result.
Yes.
Therefore, my submission would be, my lord, kindly, the court should leave it as it is. There is a definition of court in 21E. Section 29A uses the word court. Section 34 uses the word court. Therefore, please apply that definition and let the court be as a principal civil court instead of trying to interpret it through the eyes of Section 11. This is not where we are coming and objecting to it. Saying that you don't have to interpret it through the eyes of Section 11, 5 and 6 at all.
Yes, okay.
Otherwise, the legislature itself would have provided for the same. And said court in this case would really mean the courts under Section 11. Because there are varied situations. There's not only one situation Section 29A contemplates. 29A has the extension clause. It has imposition of costs. And it is not as if I'm sorry, but we can't also in that sense disrespect a principal court of civil jurisdiction in a district by saying that, sorry, you're not competent to really substitute an arbitrator. Whereas, admittedly, you have the power to set aside an award which has been given by arbitrators appointed by the Honorable Supreme Court also. I'm sorry, my lord, I find this, my lord, to say that, my lord, a principal civil court will not have jurisdiction. My lord, they may or may not exercise that. Why is it we are assuming that in every case, my lord, there will be a substitution? Why are we assuming, my lord, that in every case the award will be set aside? No. My lord, the principal civil court might look at, my lord, the award. Maybe, my lord, give respect, my lord, it is up to the court to see, my lord, whether, my lord, award is by someone who is trained in law, whether he is a retired Supreme Court judge, not a retired Supreme Court judge, and give him that leeway. It is the discretion is completely with the principal civil court. So that's my submission, so far as the sections are concerned. I've always believed that if you look at a section and see what it really implies, then the cases really come and try to interpret that. Now, we have the Allahabad decision, which my learned friend wanted to distinguish.
Yes.
I found that that is something which takes care of most of the situation, as I've said, and also limit resources. I'll rely on Allahabad. I'll also quickly run through the other cases, and limit resources. In fact, of the Honorable Supreme Court seals that issue with regard to definition of court. That is what my endeavor will be. First, kindly come to this
the Allahabad case.
Yes, that is
Zinco.
Yes, Inco. I find it very difficult.
Inco.
Inco, most probably. I think the X is not pronounced. Most probably, I'm not very sure.
Okay.
Kindly come to paragraph 54. Paragraph 54, Mullah.
In view of discussions, in view of aforesaid.
Yes, Mullah. In view of aforesaid. Mullah, it says in view of aforesaid. Sorry, Mullah, I just give. Yes. This is page 31, Mullah. It should be Mullah in my Lord's compilation. In view of aforesaid, intention of legislature is to include a High Court, specifically having jurisdiction over aspects which specific provisions of the Act of 1996 has clearly been delineated. However, no such amendment has been incorporated in Section 21E to exclude a civil court of original jurisdiction so far as it pertains to Section 29A of the Act. Considering in the light of amendment made in Section 47 and 56 of the Act, the intention of legislature to include a High Court only when it is original jurisdiction thus clear and unambiguous, and in such circumstances where there is no ambiguity, no purposive interpretation is required to be restored to implant a perceived causes, which even casus actually, which casus, not causes, casus, which even otherwise was not omissus. So this is not that casus omissus, we will not supply something which is not there in the statute. That's the principle. It is also evident that the judgment rendered in Indian Fertilizers takes into account a supposed anomalous situation where an arbitrator appointed by the Constitutional Court is substituted by District Court. The aforesaid proposition clearly does not take into account a situation where an award rendered by an arbitrator appointed under Section 11(6), kindly similar, this is what I was arguing, under Section 11(6) of the Act of 1996, can be set aside by a commercial court exercising powers under the Act of 2015, read with Act of 1996. Once a commercial court has the power and jurisdiction to set aside the award of an arbitrator appointed under Section 11(6) of the Act of 1996, it does not stand to reason as to why such an arbitrator cannot be substituted, exercising powers under Section 29A of the Act in the circumstances indicated therein. Taking the aforesaid proposition of Indian Fertilizer further to its logical conclusion, it would mean that any award rendered by an arbitrator appointed under Section 11(6) of the Act would necessarily be required to be challenged only either in the High Court or in the Supreme Court. But the said proposition law has already been rejected by the Supreme Court in the case of Atlanta, which one is accepted. Then 56, judgment in Indian Fertilizer also incorrectly presupposes that all appointments of arbitrator would be only under Section 11(6) of the Act and does not take into account when an application under Section 29A has been filed in an arbitration where arbitrators have been appointed by mutual consent. Making such a distinction again would amount to including words and phrases in Section 29 of the Act where they have not been deliberately incorporated in the wisdom of the legislation. The judgment in Indian Fertilizer also does not take into account a situation where an arbitral tribunal comprises some members appointed mutually and others appointed under 11(6) of the Act, as in the present case, where one arbitrator was appointed by mutual consent and the other under 11(6) of the Act, and subsequently the presiding arbitrator was appointed by consent of both parties. Well, in our case, all three have been appointed by the procedure which was agreed upon. At the cost of repetition, such a distinction not having been made under Section 29A in the considered opinion of this court cannot be inserted by judicial legislation. Well, I'm adopting this argument, and that's what I've argued.
Right.
In the case of 59, in the case of Indian Fertilizer, the powers of substitution under Section 29A of the Act has been made referable to Sections 14 and 15 of the Act without considering the distinction in substitution of arbitrator under provisions of Section 15 and Section 29 of the Act. It is relevant to indicate that under Section 29A, substitution of arbitrator is an instance of the court, and under subsection 7, the arbitral tribunal thus reconstituted is deemed to be in continuation of the previously appointed arbitral tribunal, whereas under Section 15 of the Act, substitution of arbitrator is to be without intervention of court, as per rules which were applicable to the appointment of arbitrator being replaced. Subsection 3 of Section 15 of the Act does not indicate that the reconstituted arbitral tribunal would be in continuation of the previously appointed arbitral tribunal. Even otherwise, provisions of Section 29A cannot be said to presuppose an automatic substitution of arbitrator, and as such, the basic premise of the aforesaid judgment, with all due respect, appears to be flawed. The submission of learned counsel to applicants is that the provisions of Arbitration Act in variance with Section 15 of the Code of Procedure with regard to grade of court where proceeding can be entered in first instance, therefore application 29 is required to be filed only in the High Court in order to lend credibility to the proceedings. Then Mulad 61, the associated contractors is dealt with. Can you see? Framers of the statute must certainly be taken to have been conscious of the definition of court in the Act. It is easily permissible to contemplate that they did not want the power under Section 11 to be conferred on the District Court or the High Court exercising original jurisdiction. The intention apparently was to confer the power on the highest authority in the state and in the country on the Chief Justice of High Court and on the Chief Justice of India. Such a provision is necessarily intended to add the greatest credibility to the arbitral procedure. Argument that the power thus conferred on the Chief Justice could never be delegated to any other judge of the High Court or the Supreme Court stands negative only because the power given to designate another. Intentional legislation appears to be clear that wanted to ensure that the power under 11(6) of the Act was exercised by the highest judicial authority in the state or in the country concerned, that is to ensure the utmost authority to the process of constituting the arbitral tribunal. Then paragraph 18 is set out. Then kindly come to paragraph 62.
Yes.
The aforesaid submission also does not hold good ground, since the said aspect has already been taken care of in the definition under Section 2, where the highest grade of court, that is High Court, has already been included in the definition of court, but only in excess of its case it exercises original civil jurisdiction subject to condition indicated there. Then learned counsel for applicant is also adverted to the fact that the part under 11(6) of the Act is subsequently held to be subject to review in view of the fact that the High Court as a superior court of record can entertain review. Then, my lord, 11(6) is considered 65. Then, my lord, I just want my lord to come to straight away, my lord, paragraph 60. Sorry, my lord, just a minute. 66, my lord, which is
page 42.
My lord, page 42, my lord. Sorry, page 42. A perusal of aforesaid judgments indicates that the same have been rendered on the proposition that the right to substitute can be exercised only by a court which is the power to appoint, and the substitution in fact of arbitrators appointed in 11(6) of the Act would lead to an anomalous situation. The said aspect of the matter has already been dealt with here and before, and therefore no further explanation same is required, particularly in light of judgments rendered by the Honorable Supreme Court, that interpreting the provisions in the manner as have been done in the said judgments would in fact lead to an anomalous situation. 67, concept of judgment having been rendered per inferium has been considered case of Jyoti Verma. We don't need to go into that. Then, 68. Upon applicability of the aforesaid judgment, clearly the ratio decidendi enunciated not only by previous coordinate benches of this court, but also by the Supreme Court indicated above, as well as specific provisions of statute in the considered opinion of this court, and with all due respect would not be considered a case of Indian fertilizer, due to which it cannot be said to have attained the status of a binding precedent. In light of aforesaid aspects indicated above, the question is answered as follows. Concept of court as envisaged under Section 29A, read with Section 2(1)(e), does not include a High Court, not having original jurisdiction in the case of Allahabad High Court, and an application as such under Section 29 Act would be implemented only in the principal civil court of original district. At the present, and does being not implemented, such are dismissed. So, Lord, my submission is that, Lord, it considers, Lord, as to the fact of, Lord, that only one kind of situation can be contemplated under Section 11, 5 and 6 to, Lord, give a color of interpretation to, Lord, Section 29A. And, Lord, the logic also, Lord, which I submitted, saying that you can't hold, Lord, the appointment in such a, Lord, exalted position, my lord, if I may use that expression, to say that because even an award given by, my lord, anyone, my lord, can also be set aside. That jurisdiction is, my lord, with the principal civil court, my lord, of original jurisdiction. Then, my lord, kindly, straight away, my lord, after this, my lord, kindly take, my lord, Nimit, and then, my lord, I'll show, my lord, the other judgments. Kindly see, my lord, Nimit.
Yes.
Which is, my lord, at, I think, pages 94 to 98 of my lords.
Yes.
My lord, the brief, my lord, and kindly see an application, my lord, an application.
Yes, next.
Has been, yes, an application has been, my lord, I'm reading, my lord, paragraph 1 itself.
Yes.
An application has been filed by the appellants invoking jurisdiction of this court, purported to be under Section 14 of the Arbitration and Conciliation 1996 for, and is, my lord, terminating the mandate of the sole arbitrator for appointment of substitute arbitrator, as also for withdrawal of the authority in terms of Article 8 of the appointment of arbitrators by the Chief Justice of India, Scheme 1996. Indisputably, disputes and differences have arisen between the parties, there existed an arbitration agreement. An application under Section 11(5) of the 1996 Act was filed being arbitration petitions and such by an order dated 27 September, Sri B.J. Diwan, former Chief Justice of Gujarat High Court, was appointed. In its order dated 27 September, the court directed the sole arbitrator would determine the question as to whether there exists valid arbitration agreement between parties and consequently had jurisdiction to conduct the proceeding for arbitration or not. An application was filed by the respondent before the arbitrator on or about 20th August 2001. He passed an interim award, opining that he had jurisdiction to proceed further in the arbitration proceeding and determine the dispute between parties. Then 4, indisputably, no final order has been passed by the learned arbitrator. Whereas 5, allegations have been made in the application of learned arbiter unnecessarily been delaying the arbitral proceedings and had not been taking any initiative to dispose of the same. The respondents contend that the proceedings before the learned court has been going on without any delay. Then, my lord, they say it's a judicial order. Then, kindly similar 8, paragraph 8. Application in terms of subsection 2 of section 14 thus lie before a court within the meaning of the 1996 Act. It is only thus the court within the meaning of the provisions of the said Act which can entertain such an application raised by the parties herein and determine the dispute therein on merit. Then, unlike the 1940 Act has been defined, 1940 Act, court has been defined in section 21E to mean, then not set out. 11. As a court has been defined in 1996 Act itself, an application under section 14(2) would be maintainable only before the principal civil court, which may include a high court having jurisdiction, but not this court. This court, in passing its order dated 27/9/2000, as noticed herein before, did not, kindly similar, very important, did not, because here the appointment was by the Honorable Supreme Court itself, did not and could not retain any jurisdiction itself, as could be done in suitable cases under the 1940 Act. It even did not determine the validity or otherwise of the arbitration agreement. It allowed the parties to take recourse to their remedies before the learned arbitrator. When the said order was passed, this court was considered to have only an administrative power. The same has since been held to be a judicial power in SBP. The said jurisdiction, however, does not extend to section 14 of the Act. The definition of court indisputably would be subject to the context in which it is used. It may also include the appellate courts. Kindly similar. It may also include the appellate courts. Once the legislature has defined the term in the interpretation clause, it is not necessary for it to use the same expression in other provisions of the Act. It is well settled that meaning assigned to a term as defined in the interpretation clause, unless the context otherwise required, should be given the same meaning. 14. It is also well settled that in the absence of any context indicating a contrary intention, the same meaning would be attached to the word used in the letter as is given to them in the earlier statute. It is tried that the words or expression used in the statute before and after amendment should be given the same meaning. Settled law that when the legislature uses the same words in a similar context, it is to presume that in the absence of any context indicating a contrary intention, same meaning would attach to the word. It is then, it is in Venkata Subramani versus Ramaya, the state and act should be interpreted having regard to its history. Then, 16, such a question does not arise. Then kindly come to 18. Very important, paragraph 18. Jurisdiction under section 11(6) of the 1996 Act is used for a different purpose. The Chief Justice or his designate exercises a limited jurisdiction. It is not as broad as subsection 4 of section 20 of the 1940 Act. When an arbitrator is nominated under 1996 Act, court does not retain any jurisdiction with it. It becomes functus officio, subject of course to extra jurisdiction in terms of the constitutional provision of the Supreme Court rules. The said decision therefore have no application in this. Yes, Reliance based on Yatish not. Now, my lord, kindly also look at, since my lord, we are examining this question, my lord, kindly look at my lord, section 14 and my lord, section 15 of the Arbitration Act now.
Yes.
Now, my lord, kindly see 14.1. The mandate of an arbitrator shall terminate, and my lord sees, he shall be substituted by another arbitrator if he becomes de jure or de facto unable to perform his functions or for other reasons fail to act without undue delay, and he withdraws from his office or the parties agreed termination. So, delay is also considered here. Then 2, if a controversy remains concerning any of the grounds referred to in clause A of subsection 1, a party may, unless otherwise agreed by the, apply to the court to decide on the termination of the mandate.
Yes.
So, my submission is, 14 also the similar situation. None of these judgments, which have held a contrary view, has considered scope of section 14. Section 14 also refers to termination of mandate of the arbitrator, and he can be also substituted by another arbitrator. And how is mandate terminated? If he becomes de jure or de facto unable to perform his functions. And if he does not proceed without undue delay. So, irrespective of whether he has been appointed by the Honorable High Court or the Honorable Supreme Court, if today a principal civil court of district, highest principal civil court of the district considers that, sorry, Mr. X, who's been appointed by the arbitrator by the Honorable High Court, and in this case, even it extends to perhaps to the Supreme Court as well. If he's failed, if he not proceeded with delay, with dispatch or without has delayed the arbitration, he can be substituted. And 14, in the context of 14, the courts, Supreme Court has clearly held that, I'm sorry, definition is you go to. Because may I just also submit this? The logic is this. Because 34, 29A, 14 requires more of a hearing. The legislature thought fit that when it comes, if there's a procedure of appointment of arbitrator, the initiation should be, if there's a failure of the procedure, the initiation should be by appointment of the Honorable Supreme Court or of the Honorable High Court, so that the process is started. And these are all a failure mechanism. This is not the initial process of starting the arbitration at all. These are all failure mechanism. When the arbitration has not gone as was contemplated, then it's the principal civil court. 14 is clear. There's no answer of in any of the judgments and of my learned friend on the other side, learned advocate general, how 14 fits in. So I submit that. So these two judgments, the and sorry, also 15 will kindly see.
15.
15 also it does defines 14.
Termination.
Yes. And 15(2) requires where the mandate terminates, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. So termination is decided, and then either substituted by court or in terms of the original agreement as defined. So I'm saying the definition of court in section 29A is not required to be interpreted or looked through to the spectacles or through glasses in section 11(6), 5 or 6. It only falls back on section 21E, and that's what the courts have, some of the courts have held. And I understand, of course, some of the other learned judges may have not seen it that way, but I am saying why it should be. Then kindly come to our next judgment. So I am actually relying on Nimet resources more than anything else, and the Allahabad judgment, and then kindly look at Magnum Opus. This is the second judgment, pages 45 to 55, and kindly take
Yes.
Paragraph my lord 18.
Excuse me.
Paragraph 18.
Yes, from plain
From
reading.
a plain, yes, my lord, from a plain reading. From a plain reading of this provision, it is clear that the case of international commercial arbitration, court would mean the High Court in excess of the ordinary having jurisdiction to decide the question from the subject matter arbitration, same had been the subject matter of suit, or the High Court having jurisdiction here appeals from decrees of court subordinate to the High Court. In arbitration proceeding other than international commercial arbitration, court would mean the principal civil court service. Then, my lord, I'm sorry. Kindly come to my lord. 19. Cabra is considered, my lord, by this, my lord, by the Bombay High Court. 19 and 20, my lord, again, my lord, this is Nilesh Ramandhai as well as Tarachan. All my lord are considered. Then, my lord, 21. There are conflicting views as regards the jurisdiction of the district court to extend the mandate of or substitute arbitrator under section 29A of the Act in Leeladitya Dev, which I've just showed, my lord, the Odisha. No, sorry, I haven't shown that, my lord. That's, my lord, later, my lord, in my list. I'm so sorry. Then kindly come to paragraph 23. It is
Pertinent.
yes. Just before that, I'm sorry, my lord, may I just show the line before that, my lord, the question, this paragraph, end of paragraph 22. The question whether the term court as defined in section 2(1)(e) of the Arbitration Act can be interpreted differently in the context of section 20, and it did not fall for considering these two decisions. Then, my lord, 23 is pertinent to note that section 2 begins with unless the context otherwise requires. Hindustan Construction Limited onwards Supreme Court, while considering the contention the term court can be assigned different meaning depending on the context, referred to as three-judge bench, United Medical Agency. Sansad, when it is held that well settled principle that when a word or phrase has been defined in the interpretation clause, then my lord relies on Sansad referred to three-judge bench. Then, my lord, I'm sorry, my lord, I'll just kindly come to 26. In the instant case, the district court has substituted the arbitrator in excess powers under section 29A of the Act and Arbitration Act. It is not in dispute that the arbitration proceedings had commenced under section 18 of the Medium-Small Act. The council had not concluded the arbitration within a period of 90 days stipulated under subsection 5 of 18 of MSME Act or within the time limit under section 29 of the Arbitration Act. In fact, there were absolutely no progress in arbitration period over 33 years. Inaction of the arbitrator rendered the arbitration scheme under the section 18 nugatory. There being no provision under the MSME Act to extend the mandate of the arbitrator or substitute the arbitrator, only remedy available to the respondent was to approach the court under section 29A of the Arbitration Act. And accordingly, respondent filed an application 29 and 27. It is not in dispute that the district court, Nashik is the principal civil court of original jurisdiction district having jurisdiction to decide the questions forming the subject matter of the arbitration. If the same had been the subject matter of suit, as noted above in the instant case, arbitration proceeding commenced under section 18 of the MSME Act. The arbitrator was neither appointed under section 11 of the Arbitration Conciliation Act nor substituted by the court under order dated 17 November. By this order, this court had revived the arbitration proceedings which were closed by the council. Hence, in the context of present matter, interpreting the word court to mean principal civil court of original jurisdiction does not lead to an anomalous situation and does not give rise to conflict of powers. On factual aspect, decision in Cabra, Installationio, Nilesh Patel and Taracha distinguished, hence there is no scope to depart from the normal rule of giving effect to the meaning of the term as defined in the Act. So, this judgment, my lord, I am only showing to show, my lord, that the different situations are contemplated as to why, my lord, one can come under section 29A. So to always link it with an arbitrator appointed by the High Court or the Honorable Supreme Court and then say that, no, this is how you should interpret the court is, my lord, something, my lord, which we are, my lord, against. And this is, my lord, what, my lord, where the issue, my lord, lies. Now, my lord, next one is, my lord, Liladitya Dev, my lord, paragraph 20. Actually, paragraph 15, my lord, the discussion starts at Liladitya Dev. And kindly come to, my lord, paragraph 20. My lord. Yes. Further, for the petitioner failing to establish that district judge, Bhubaneswar is not the court in terms of decision at section 2E of the Act 1996, so as to undertake an exercise under section 29A of the Act. The decision relied on by the petitioner has no application to the case at hand. For nature of disputes, extension of mandate of arbitration seems very much warranted for no passing of award by the arbitrator in time stipulation. There is bound to be an extension of mandate of arbitrator to achieve a complete effect with the proposed appointment, failure which may lead to multitude. There is no end to the dispute involving the parties. I say the court find the petitioner otherwise also not prejudiced. Before that, let's discuss why this court would be the district court at Bhubaneswar. Then, this is very important. The next judgment, this is of the Guwahati High Court. A plus projects.
Yes, I couldn't hear you. Guwahati High Court judgment. What do you want to show from that?
Next, the next judgment in my lord's list is Ek and Company. Now, Ek and Company only will make a note of paragraph 5.
So that's page.
That's page 74 to 77, of my lord's compilation.
Yes.
It relies on, if looks at paragraph 4, it relies on rely on a decision of the division bench of this court in Lodge Shipping Company versus Cochin Port. And in that, may I just read from the division bench paragraph inside that quotation in paragraph 4, the learned judge looked at paragraph 7 and 9. So kindly look at paragraph. In that judgment, paragraph 9 looks at a division bench judgment, and then paragraph 5 of the judgment is what has to be considered. And I'm showing how the judges have taken a view. Honorable judges have taken a view depending on how the appointment is. But I'm praying.
No consistency, Mr. Banerjee. In all the decisions, like we saw earlier, depends on a case-to-case basis. I mean, they're trying to. There's a distinction that they're brought in.
I'm so grateful, I'm correct. That's why, I only want to rely on the Allahabad High Court judgment and Nimet resources and A plus, which I'm going to show the Guwahati High Court. And that's why, my submission is that kindly take a consistent view with regard to interpretation of section 29A, saying that, and that is my most humble submission, that it is the definition of section 21E. And why should we look at it from through section 11.6 or 5?
So you mean that the definitive section shall prevail?
Prevail. Otherwise, the legislator itself would have said. Yes, because section 11.6 makes an exception. 11.5 and 6 itself makes an exception. If that exception was required to get away from the general definition, legislator would have said so. And I've shown section 14, that also contemplates termination of mandate and substitution.
Yes.
Section 34, my lord, also, my lord, has the word court. Similarly, my lord, Section 29A also has the word court.
That's what you said it should, what has been defined as court in 21E should prevail over other else. These 11, 5 and 6 an aberration.
Yes, my lord. Absolutely. Absolutely. Those are, my lord, special procedure, my lord, as my lord.
Okay, not aberration, but yes, a special fail-safe provisions.
Yes. Well, I wouldn't like, my lord, to say, my lord, aberration. So, my lord,
fail-safe. The fail-safe provisions, yes.
Correct. I'm saying that's a special procedure for courts when the initial appointment comes up, not, my lord, when the conduct of the arbitration is concerned, my lord, subsequently.
Okay.
And the reason being, my lord, Section 11.6, my lord, has seen 11.5, 11.6 when my lord appoints. There is really very little scope, my lord, of not appointing an arbitrator. Only, my lord, as the Supreme Court has said, when it's a dead claim, dead wood, as, my lord, the Supreme Court's used. Otherwise, my lord, you leave everything to the arbitrator. So in that sense, my lord, the jurisdiction is also not summary. The High Court, my lord, now can't be, my lord, involved, my lord, in the question of, my lord, seeing whether, my lord, a termination mandate has happened, whether I should extend, not extend. So there is no speciality.
Mr. Banerjee, according to our understanding is that Section 11 is that when the matter comes before the High Court, we just see whether there's arbitration clause there or not. That's all. It's limited to that, and then we appoint arbitrator. That's all.
Absolutely.
I mean, we're not going to go beyond that because arbitral tribunal is the best. Is the best. Like forum for all to be decided, not for the High Court to go into those kind of things.
My lord, absolutely, my lord, and I'm relying on my lord's, my lord, what has just fallen from my lord to say that is exactly the jurisdiction of 11.6. Now 29A, if it gets into a controversial situation, why should, my lord, the High Court then exercise, my lord, come through 11.5 and 11.6 to say, no, I will now exercise jurisdiction under Section 29A also. It is either a mere extension or, my lord, imposition of. If it's mere extension, it's very simple. Or, my lord, it's a question of, my lord, substitution. My lord, is a very heavy, my lord, requires, my lord, really, my lord, akin to 14, where, my lord, it's been delayed. 14, Section 14, my lord, jurisdiction, and, my lord, 29, my lord, to that extent, my lord, is somewhat overlapping also.
Okay.
When it's beyond 1.5 years, then, my lord, one comes to, my lord, under 29A for extension. And at that time, my lord, if the court feels that in 1.5 years, well, the arbitrator has done nothing, court might say, very well, I'm sorry, I don't really subscribe to this. Well, kindly look at A+, my lord, this is the judgment at page 78 of my lord's brief, my lord, the compilation. Well, this is of my lord, Justice Bhuya, my lord, as his lordship then was. And then kindly see my lord, paragraph 2.
Yes.
This is an application filed under 11.2 of the Arbitration Constitution, read with 11.6, 11.8, and Section 29A4 to 29A9 of the said Act. Then, number 3, by filing this petition, the petitioner seeks appointment of additional arbitrators having expertise, as well as for extension of the period. Then, my lord, kindly see paragraph 7.
Paragraph
7, my lord.
7.
Second line, however, respondent did not proceed with arbitration, which compelled the petitioner to move the Court of District and Sessions Judge, Dibrugarh, under Section 9 of the Arbitration Constitution. While disposing of such petition, Court of Learned District and Sessions Judge, Dibrugarh, made observation regarding reference to arbitration for settlement of disputes. Finally, respondent informed the petitioner with a letter dated 16 June 2016 that Sri P.C. Sansach, retired district and session judge, be appointed arbiter, sub concerned arbiter, and mentioned there should be 7 different arbitration petitions related to 7 numbers of purchases. Then, my lord, kindly come to 15, paragraph 1515.
Yes.
Those several objections, respondent has filed an affidavit raising preliminary objections. Those several objections have been raised, preliminary question is the petition so filed is not maintainable as much as the same is required to be filed before the principal civil court and not before the High Court. The other main objection is that the 1996 Act does not provide for extension of an arbitral tribunal, though it is provides for appointment of experts to report to the arbitral tribunal on specific issues. That was the objection raised. Then, my lord, kindly come to paragraph 20. As already noticed, in this case, learned arbitrator was appointed by the parties themselves without intervention of this court. Section 21E defines court. Section 2 forms part of Part 1 of the 1996 Act, which covers Section 2 to 43. It says that unless the context otherwise requires, court means in the case of an arbitration other than international commercial arbitration, principal civil court of original jurisdiction, a district, and includes the jurisdiction and includes, covers so a district and includes the jurisdictional high court in exercise of the ordinary original jurisdiction. Is that question? Then, paragraph 21. This case is not concerned with international commercial arbitration. Therefore, as per the definition clause, court would mean the principal civil court of original jurisdiction in a district and would include the jurisdictional high court in exercise of its ordinary original civil jurisdiction. Then 22. Section 11 of 1996 deals with the appointment of arbitrators. While under subsection 2, parties are free to agree on a procedure for appointment arbitrators in case of failure to reach an agreement. Procedures for appointment of arbitrator laid down in the following subsections, which includes appointment of arbitrator by the High Court or an appointment case by the Supreme Court. Then 23, section 29 deals with time limit. Then, my lord, straight away kindly come to paragraph 26 and 27. 26, 27, 28. The question which therefore arises is what would be the meaning of the term court? As noticed above in terms of the definition clause of section 21E, court means principal civil court of original jurisdiction in a district and includes the jurisdictional high court in exercise of its ordinary civil jurisdiction. Therefore, it is quite clear that the court would mean principal civil court of original jurisdiction, also the high court in exercise. Guwahati High Court does not exercise ordinary original civil jurisdiction. Therefore, to my mind, the terms court appearing in subsection 4 of section 29A of the 1996 Act means the principal civil court of original jurisdiction, and in the context of the present case, it would mean court of the district and session judge Kamrup, Metro, Guwahati. A reading of the 1996 Act would go to show that whenever the legislature, this is what I'm relying on, wherever the legislature intended that a particular power is required to be exercised by the High Court or the Supreme Court, the same has been specifically mentioned. For example, in section 11, but in other provisions, legislature has used the term court, which is defined in section 21E of the 1996 Act. Therefore, there cannot be any iota of doubt that the term court appearing in section 29A of the 1996 Act would mean principal civil court of district having jurisdiction and would include jurisdictional high courts if it exercises ordinary original civil jurisdiction. As has been held above, the context of the present case, court would mean court of district and sessions judge Kamrup. Then, my lord, 29, State of West Bengal, my lord, is considered. Kindly see, my lord, 29 also important. State of West Bengal was an associated contractor. Supreme Court declared unequivocal term that section 218 of the 1995 contains an exhaustive definition marking not out only principal civil court of original jurisdiction, district or high court, having ordinary civil jurisdiction state, and no other court as court for the purpose of part 1 of the Act. Then, my lord, State of Jharkhand is, my lord, relied upon. My lord, 29, and then, my lord, 32, my lord, that URC construction, my lord, is also looked at. And then, my lord, 33, I may see, my lord, Gujarat High Court. My lord, the learned judge also deals with, my lord, the Gujarat High Court, my lord, case. High Court in the case of Banubhai Ramanbhai Patel Supra referred to subsection 2, subsection 6 of section 29 of the 1996, which empowers the court to substitute all or one of the powers, and took the view that if the court is understood to mean only principal civil court or high court having original civil jurisdiction, that the situation may arise when an arbitrator appointed by the High Court or the Supreme Court may be substituted by the principal. Well, this is the, and then we'll kindly say the last 3 lines of that paragraph. interpretation given by the Gujarat High Court, though highly debatable, was in that context, which is certainly not the case of presentation. Therefore, even factually decision of Gujarat High Court is distinguished. And we're not coming to the second aspect, it extends it. And then, my lord, 41. Paragraph 41. The learned judge holds, thus having regard to the discussion made above and in due consideration, the two issues answered negative. Consequently, court is of the view that the present petition not maintainable. However, petitioner may approach the principal civil court, that is Court of District in Sessions as Kamrup Metro, Guwahati under Section 29A4 of the Arbitration Constitution for an extension period. Arbitration is such petition failed, etc.
Yes, anything else?
Yes. So, my submission, therefore, and also, one more, one more judgment. In that, we'll find Patel Engineering Company versus State of Meghalaya. Of my Lord's Court. Here, my lord, also there was a question of a section 14 to application. This is at pages 99 to 102.
Yes.
And will kindly take paragraph 9 onwards. Similar, in similar vein, I do just because it's my lord's the Honorable Meghalaya High Court, I wanted to show that 9 now coming with section E, then paragraph 10. On perusal of the definition, court as enumerated set act referred to as above, it is clear that court means principal civil court of original jurisdiction district includes high courts and such. Unclear. Then 12 is followed on the that not charter high court. This is the logic of the court here. Now, just two more things. My learned friend's judgments.
Yes.
Kindly see the Swadesh Kumar Agarwal, paragraph 21 and 32.5. Kindly see what was the question which was not being decided. Kindly come to, my learned friend relied on this, kindly similar. I don't know whether therefore, on a conjoint reading of sections 13, 14, and 15 of the Act, if the challenge to the arbitrator is made on any of the grounds mentioned in section 12 of the Act, the party aggrieved has to submit an appropriate application before the arbitral tribunal itself. However, in case of any of the eventualities mentioned in section 14(1)(a) of the 1996 Act, and the mandate of the arbitrator is sought to be terminated on the ground that the sole arbitrator has become de jure or de facto unable to perform his functions or for other reasons failed to act without any undue delay, the aggrieved party has to approach the court, kindly see, as defined under section 21(e) of the 1996 Act. The court concerned has to adjudicate whether in fact the sole arbitrators have become de jure or de facto unable to perform his or their function or some other reasons he fails to do so without undue delay. The reason why such dispute is to be raised before the court is that eventualities mentioned in section 14(1)(a) can be said to be a disqualified sole arbitrator, and therefore such a dispute controversy will have to be adjudicated before the court concerned as provided under section 14(2) of the 1996 Act. Well, I don't know how much of this helps my learned friend, because this also in fact says what I'm trying to say. Then can you also see 32.5? it my lord, goes against my learned friends, my lord. In a case where there is a dispute, controversy on the mandate of the arbitrator being terminated on the ground mentioned in section 14(1)(a), such a dispute has to raise before the court defined under section 14(1)(a), defined under section 21(e) of the 1996 Act, and such a dispute cannot be decided on application filed under section 11(6) of the 1996 Act. So, my lord, if 14 jurisdiction, my lord, with regard to deciding the termination of a mandate, which is also appointment, my lord, by the High Court or my lord, by the Supreme Court, and my lord, substitution has to go to 21(e) court. There's no reason, my lord, why, following my lord, similar logic, that will, my lord, then, my lord, be looked at through 11(6) and say that no, sorry, you have to go to the High Court. And my lord, the other judgments, my lord, Whirlpool, my lord, is, my lord, different meaning in different contexts, my lord. That is 1998 8 SCC, which, my lord, my learned friend relied upon. Different meaning in different context. Yes, my lord, I am, my lord, not saying, my lord, it should not be, but I'm saying, my lord, here, my lord, there is no different context. And that state of Maharashtra also, my lord, 2002 Supreme Court cases 589, that related, my lord, to opening of new medical colleges. So all these judgments, my lord, are on the question of, my lord, interpretation of, my lord, the last two judgments, interpretation of, my lord, the statute to say that it should be contextually interpreted. My lord, I am not joining issue, my lord, with regard to contextual interpretation, but I am on the question, my lord, that here there is no necessity for any contextual interpretation because the legislature is very clear. And, my lord, at the end of, my lord, my learned friends hearing, my lord, what fell from my lord, and which, my lord, I again, my lord, respectfully, my lord, totally, my lord, agree. My lord, if the legislature wanted, legislature would have done that. They are amending the Act in 2015. They are amending the Act in 2019. If they thought, my lord, this kind of application would have to go to the High Court or the Supreme Court, as the case may be, they would have put that in and not left it, my lord, to the definition of court. Not left it, my lord, to the definition of, my lord, court in section 2(1)(e), which is the only definition which is there, which governs, my lord, 34, 14, section 14, section 29(a), section 9. So you can't have, my lord, to say now that, my lord, when one substitution power is there under section 14, I will not use the definition of section 11(6). But when 29, we come to 29(a), because all the arbitrators can be substituted, I will then now use the definition. My lord, I'm sorry, my lord, this will really lead to, my lord, quite, my lord, a anomalous situation. And what, my lord, Delhi High Court considered and what, my lord, Delhi High Court said, saying that no, because the High Court had appointed, Delhi High Court, my lord, forgot to notice that there are several arbitrations, my lord, which are, my lord, proceeding, or, my lord, several cases, my lord, where the arbitrator has not been appointed, my lord, by the High Court at all.
Anything else, Mr. Banerjee?
My lord, I think, my lord, those are my submissions. My lord, I'm my lord, so grateful. My lord, my lord, unfortunately, my juniors are, my lord, all over, my lord, the country now. My lord, I don't think Sania or anyone else, you want any other point to be submitted before my lord? No, I don't think so, my lord. I'm so grateful, my lord. It's been a pleasure, my lord. It's always been a pleasure, my lord. I've been before my lord. It's always been a pleasure.
Yes, I hope we can conclude it, subject what they have to say.
Well, just a few brief points, although with permission of this court, because
I'll have my lord's leave, my lord. I'll have my lord's leave, my lord.
Yes.
Is it my lord's pleasure, my lord, that we should file, my lord, written notes, or my lord has got, my lord, the...
It's better if I written notes, yes.
Very well, my lord.
But not too long. I don't like written arguments. Yes.
No, my lord, 2 or 3 pages, my lord, maximum, my lord, 2 or 3 pages, my lord.
Just
Grateful.
Yes.
Yes, my lord. Now, the first
You're
argument,
watching it on YouTube.
I was watching both the matters, my lord.
First argument, proceeding under 11.
You have seen. My lord, the first argument is that court has been used in section 34, 29A,
Yes.
and
That's very important.
so that's a
the thing is that,
that
one point which is, which this court thinks really considers that.
yes, my lord.
See, under 34 now, the principal civil court has been given the power to set
Yes,
set
my
aside awards.
Yes,
Correct?
my lord.
Yes.
Now-
So irrespective of where the award comes from.
Yes, my lord. That is the one
So
aspect
if
which
that court, the
has the
submission
power
of,
to-
of the other side is that the definition of court as against different section should prevail. It's over. I mean,
That is
the entire, what do you call it, spectrum of
Spectrum.
all other sections. Like,
Yes.
that court should be understood as what is given in 2-1.
yes, my lord. If I have understood the argument correctly,
Yes.
court used in section 2(1)(e) has to be read uniformly throughout the entire act, whether it's a section in 34 or 29A or 14. So this is the argument. This is the basis on which it is being said that the definition clause. If your lordship kindly see the act once again, 2(1).
I'm not going to go. We're going to answer on points.
Yes.
On law. On
Law,
point-
law only, my lord.
Yes.
Law 2(1)(e).
Court means
2(1)(e). 2(1). First, your lordship kindly see 2(1), because 2(1) is most important. I did not get answer to my this very issue, my lord. In this part, unless the context otherwise requires, and this is unless the context otherwise requires is also part of E only, my lord. 2(1)(e), because definition 2(1)(e), what my friend is saying, my lord, if your lordship will see again, the court means, at the foot of the court means. So court has to take color from this part, my lord, unless the context otherwise requires. This is also part of definition clause only, my lord. This unless the context otherwise cannot be detached, detagged, and removed from the definition given in court, my lord. Now the question is, my lord, that 29A, kindly see 29A 6 and 7. 29A 6 and 7, my lord.
you can sit down, Mr. Pandey.
Pandey 6. I was watching. 29A 6, my lord.
Thought as much was the timing can't be so perfect.
29A 6, my lord. While extending the period referred in subsection 4, it shall be open to the court to substitute one or all arbitrator, and if one or all are substituted, arbitral proceedings shall continue from this
That's the only
stage.
point that troubles the
An
court.
arbitrator appointed under this section shall be deemed to have received this set of evidence. So appointed under this section. Now, then your lordship will have to take a view that principal civil judge has power under Arbitration Act to appoint the arbitrator. And this will be,
There's
this-
the only point that troubles the court.
and this is the,
That's
in
only
my
thing.
humble submission, in 11.6, this power appointment, what was flowing or what was emerging from the argument of London Senior Counsel for the respondent is that why should the High Court be troubled with 29A? High Court has also been troubled with section 11 for appointment, my lord. When it comes to appointment, my lord, this court alone has power to appoint arbitrator under domestic arbitration. And for that purpose, section 2(1)(e), my lord, says unless the context otherwise requires. I'll come to 34. I'll come. Now 7, my lord, is your lordship again 6 and 7. Your lordship has seen that it is clearly saying it is a question of appointment. When it comes to appointment, now how do I distinguish or how do I say that 34 will have no bearing so far as interpretation of 29A is concerned?
Yes.
the 34 deals with the challenge to the award, my lord. There is no provision dealing with appointment in 34.
No, but you see, the thing is that we have to keep court in mind. What does court mean?
Yes, your
so
lordship.
whether court in context of 34,
The court,
of
and if the
29,
yes, my lord.
in
So
context
for example, the section 14, my lord. Section 14 also uses the expression court, my lord. And Supreme Court says then when it comes to appointment, it will be only under 11. When the mandate will get terminated, the court in 14 has been interpreted as court under section 11, not court of the principal civil judge. That judgment, my lord, kindly see so the last paragraph of the judgment, recent judgment of rendered by Justice Shah. Paragraph 35
page.
is, my lord.
Do you have a copy of that?
Yes, that judgment is there, my lord, Swadesh Kumar.
No. Agarwal is.
Yes. Judgment. Kindly see paragraph 35. To do substantial justice between the parties and to ensure that respondent number 3 are not remediless, we direct the what has happened, my lord. I just give the factual background. One party moved for appointment under section 11, saying that the term of the arbitrator has come to an end. Other party has moved before the principal civil judge, stating that the term is to be extended. Mandate is to be extended. Sorry, the mandate has come to end because of reasons given in paragraph section 12 and section 13, my lord. The Honorable Supreme Court said that so far as court under paragraph section 14 is concerned, so far as the termination of mandate is concerned, you may go to the principal civil judge in terms of section 2(1)(e) of the code. But when it comes to appointment, the principal civil judge has no power to appoint. The matter will go to the High Court only. So therefore the court, if I take the argument of my London friend to be correct, then section 14 also the Supreme Court has accepted the court as High Court, not principal civil judge, my lord. Kindly see paragraph 35 in that light. To do substantial justice between the parties and to ensure that respondent number 1 and 3 are not left remediless, we direct that application submitted by respondent 1 and 3 before the court concerned under 14(2) of 1996 Act shall stand revived. Now the court concerned before whom the application under section 14(2) of 1996 Act were filed shall consider the same in accordance with law and on their own merit at the earliest and preferably within a period of 4 months from the date of receipt of the present order. It goes without saying that if ultimately it is held that mandate of sole arbitrator is terminated under 14(1)(a) of 1996 Act and more particularly on the ground that there was undue delay on the part of arbitrator in concluding the arbitrator's proceeding, the arbitrator has to be substituted and a fresh arbitrator has to be appointed by following same procedure which was followed earlier while appointing the present sole arbitrator. In a case parties do not agree to the name of sole arbitrator, aggrieved party may approach the appropriate court for appointment of arbitrator under 11(5) of the Act. So on termination under the court, so appointment, my lord, this why in my humble submission, appointment has been given completely different meaning in Arbitration Act because the arbitrator is not only the judge of quality and quantity of evidence, he is the final authority for determining the facts. Therefore, when it comes to appointment, my lord, either there is, if the parties are agreeing, there is no issue. If parties are not agreeing, that jurisdiction has been vested in the High Court, not in the principal civil judge, my lord. So therefore, to say that the context in which the 29A has been set in, my lord, it will have to have same meaning which is there in 2(1)(e). In my humble submission, 2(1), the court as defined in section 2(1)(e), my lord, then the very term, my lord, this very expression, my lord, that unless the context otherwise requires or will become redundant and OTOs. In order to safeguard or in order to meet out certain situation, my lord, this expression has been used and it is part of the definition. Section 11 also, my lord, if the section 11, why section 11 contemplates appointment by the High Court only. And why it is by High Court only, my lord? Kindly see the rationale of in the High Court, in the Axono only, my lord. Kindly see the rationale which has been detailed at page 33, my lord. Page 33, associate contract. Why power of appointment is exclusively vested with the High Court, my lord. And Axono, my lord, this particular aspect has been dealt in paragraph. My lord, kindly see the compilation of my friend at page 33. Kindly see 33, my lord. And associate contractor, the relevant paragraph which are as follows. The framers of the statute must certainly be taken to have conscious of definition of court in the Act. It is easily possible to contemplate that they did not want power under Section 11 to be conferred on district court or the High Court exercising original jurisdiction. The intention apparently was to confer the power on the highest judicial authority in the state and in the country on the Chief Justices of High Court and Chief Justice of India. Such a provision is necessarily intended to add the greatest credibility to arbitral process. The argument that power that's conferred on the Chief Justice could not even be delegated to any other judge of the Supreme Court stand negatived only because the power is given to designate another. The intention of legislature appears to be clear that it wanted to ensure that power under 11(6) of the Act was exercised by the highest judicial authority in the state or in the country concerned. This is to ensure utmost authority to the process of constituting the arbitral tribunal. And therefore, my lord, 29A and the reasoning given by Delhi High Court is based on some sound proposition of law, my lord. Kindly see the paragraph which has been read out in Delhi High Court judgment, my lord, that the second paragraph of Delhi High Court judgment, which is at page, my lord, 70. 79, my lord. Yeah. And then the relevant paragraph where the discussion is 25.
Where are you reading?
I am reading from page 87 of the paper book, my lord.
I think it's unending this hearing.
But that's the only I understand. My lord, it's a too tiring whole day.
No, other things that the court doesn't rehash everything.
Yes.
It's just to clarify. You
Yes, my lord.
understand?
28 only. Paragraph, page, only one, page 88. Yes, couple of this. Yes.
Paragraph 28.
27, just 4 lines, my lord. Just above paragraph 28, 4 lines. Thus, the question that poses its challenge is whether the code can be interpreted differently in context of in this part unless context otherwise. 1. Then 28. Power to extend the mandate of an arbitrator, and 29 beyond so and so, my lord. Kindly skip that part. Middle of the page. Till this point, interpreting it to mean that principal civil code as defined would, in my mind, pose no difficulty. Complexity, however, arises by virtue of the power of the court to substitute the arbitrator while extending the mandate, and this contempt becomes higher degree if the earliest arbitrator has been appointed by the High Court. Coupled with this, one cannot lose sight of the fact that legislature in its wisdom has conferred the power of appointment of an arbitrator only on the High Court or the Supreme Court, depending on the nature of arbitration, as and when power is invoked by either of the parties. There may be cases which extending the mandate of arbitrator may of the view some valid reason required to. So the reasoning which weighed with the High Court is that the appointment power has been exclusively conferred on the High Court or the Honorable Supreme Court, my lord.
But does not really matter. The only thing is that, you see, I mean, as what this court feels is that fine, we look at the larger picture. The only thing is that with that power of substitution, Now, the substitution, if the power is vested on the principal civil court, whether that amounts to denuding the powers which have been given under Section 11E, reading 29A6. That's one question which I feel needs
further elaboration, my lord. Yeah, I understand. Lordship, kindly.
That's the only thing, that because what do you call it? What will really mean by the power of substitution?
Because your lordship will see 29A6.
That's
the
it.
substitution
Yes.
means appointment.
Exactly, whether it will mean appointment.
Yes, my lord.
Whether it
29
constitute- that is the only thing.
Your lordship, kindly see
that
that.
is only that we have
Yes,
to.
kindly see
That have to be, the interpretation of that of this particular section.
Yes, Chair.
And whether if otherwise if it doesn't connote
Your
that,
lordship
then,
is right.
then
Absolutely right. Your lordship is absolutely right. Substitution means what?
Substitution means what?
In section 29(6), your lordship kindly see 29A6 says appointment, 29A6(7) says appointment. Substitution, your lordship, appointed under this section. A person will be substituted by appointment only.
because you're looking at a general, what you call it.
General
Crossing of
parlance,
law.
in general
not,
parlance.
not to look at whether the High Court is audited jurisdiction or not, or whether, but in the general scheme of things.
Yes, my lord.
as like, to give a sort of a good interpretation to the entire act. And what did it really, what is the intent of
Yes.
29A? That's
Yes.
the thing.
Yes, my lord.
Because otherwise from looking at all
It is
decisions,
otherwise it is simple.
See, this could very easy to decide it this way, that way.
Yes, ma'am.
It's very simple.
Yes, ma'am.
I can just, take the view of your Delhi High Court and,
No,
put
no,
it, I can
understand.
I can
No, because
uphold the
they-
order of
no,
the commercial court.
no, no,
I
understand.
can supplant the findings of the law. Fine, I can just,
Your lordship knows how to write a judgment both
that's
ways.
finished. Then it's just over. You go anywhere you want to go after that.
Both-
But I mean,
no,
what
the-
strikes
no,
the
this-
mind of the court only that.
this
Now,
really
that is one
poses a
thing,
good
that's
question.
one thing which
Allah.
is, has to be decided, because I don't think any decision has really, come up to any, there's no, any clear.
Yes, lordship is right. That's why your lordship has seen in Allahabad High Court, one bench is taking one view and the other coordinate bench is taking different view. There is some ambiguity. There is some ambiguity, but in my humble submission, my lord, the 29A6 and 7 have not been dealt by any.
What Mr. Banerjee said, which has struck the court, was that if the legislative intent
Yes, my lord.
was such,
So
that,
to put
that,
it to
that the
the
powers will be limited to the High Court with regard to
Yes, my lord.
in 29A, that would have been
how-
would have been indicated
how-
in the legislation itself.
So there are two ways. There are two indications.
thing which is
I must
mindful
answer
made
this.
up.
Yes, there are two things which I must answer, my lord. How do we sometimes how do we get into the indication on reading of the entire legislative scheme, my lord? Because sometimes the words have got different connotations and different meaning in different contexts, my lord. So far as there is no confusion with regard to appointment, my lord, that appointment has to be by.
I'm sorry to interrupt, but the thing is that I'm looking beyond a contextual kind of interpretation.
I'm coming. I mean, that is one.
Okay, fine. Facts were the case, but I'm looking beyond contextual. Maybe there has to be some kind of a standard.
Yes, my lord.
With regard to
Yes, my lord. Yes, what I am saying that the contextual argument is one, my lord. But the question is that under 29A, my lord, who has when it comes to substitution, whether the district judge has been conferred power of appointment also. That's a question which, in my humble submission, requires answer, my lord. Because if district judge has
the
power,
only point is grey.
Yes.
Otherwise, yes.
And if the principal civil judge has the power to appoint the arbitrator while substituting, my lord, then 29A poses no challenge. 29A poses no challenge. The challenge is on the count, and that is why Delhi High Court and series of judgments which are there in my grounds, my lord, they have taken a view that this word court in 29A will not have same meaning of 21E. Why? Because this will take the context demands something else. Context requires some other interpretation, my lord. And that is why a view has been taken for the rationale is appointment is one of the most sacrosanct part of the entire arbitral exercise. Because, and that is why your lordship has seen in section 14 also, the Supreme Court has interpreted, because it said application will lie to the principal civil judge. But when it comes to appointment, you have to go to 11. And you see section
11 is a special,
and that is why kindly see 14.
It's like a fail-safe provision. That is inserted because
yes,
suppose parties can't come. Arbitration supposed to be quick. And
Yes,
if parties can't decide on who to open the arbitrator, that's why you go to the High Court, Supreme Court, and open arbitrator. So whether that is a standalone provision, it's like, like an escape valve so that arbitration process does not get
to
delayed.
give the sanctity, to sing, give the sanctity,
Yes.
purity.
Otherwise, that very 11, 5 and 6 will, start, making, what do you call it, demands on the other, compliances with the other sections. That's the thing.
Kindly see section 14, my lord.
Yes, sometimes I feel like we go around in circles anyway. Pardon me, maybe my understanding is not to that extent. But
this is a vexed question. This is not. This is a vexed question.
Maybe my understanding is not.
This is a vexed question, my lord. Had this question not been vexed, my lord, we would not have been
arguing for 2-3 days.
And then series of judgment from both sides, my lord. It's not that judgments are not there from their side, but only thing which distinguishes my judgment from their judgment as a lawyer, my lord, is that they nowhere in none of the judgment 29A, 6 and 7 have been examined.
No, but in that allowed judgment, it's been
discussed. The question is, so I will deal with that to allow a judgment also, my lord. Also because they relied on
time anymore.
That's 2 minutes, my lord. That's done, my lord.
Yes.
So, if your lordship will see failure or impossibility to act, my lord, the mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator. Now, my lord, here also word substituted is there. And for that substitution, my lord, the Supreme Court says you have to go to section 11. The Swadesh Kumar, my lord. And that is a recent judgment, my lord, very recent. Nimet, what my London friend has relied on Nimet. And 2009, 29A was not there. There was no such issue. And 14, and particularly in 14, this issue has been examined. Recently only, because when the application was filed for termination of mandate, he said, all right, you do everything, but you can't substitute. Only code under section 11 can substitute, my lord. So I have an authority of the Apex Code defining code under section 14, my lord. The recent authority, my lord, recent judgment, that is recent judgment I have, my lord. So, and my lord, as your lordship has your lordship is absolutely correct that ultimately why 11, 5 and 6, why appointment is so important in the entire scheme of the arbitral proceeding. And that is why the legislature in its wisdom has not left the appointment to principal civil judge. Then section 11 would not have been required, my lord. If the principal civil judge has the power to set aside the judgment award rendered by the Supreme Court judges, then the principal civil judge should have been clothed with the power to appoint the judge, appoint the arbitrator also. Because this is the stage prior to setting aside or passing of the award, my lord.
Yes.
And then there are, my lord, grounds for challenge under 34 are limited also.
No, see, again, another thing is that,
that is
11 is not a strange provision. Because it does not say High Court.
Chief
Justice.
No, but that has been interpreted by the Constitution bench to mean the SBP judgment, my lord. So therefore,
but I'm talking about the intent of the legislature.
Yes, intent was that the highest apex person will appoint.
Right.
And therefore
the highest apex in a particular state.
In the judicial hierarchy.
In the state.
Yes.
Every particular High Court. That
and your lordship kindly see that has been, my friend has just instructed me that 11.6 has been changed, my lord. That definition has.
Chief Justice to it has been made a
High Court, my lord.
Oh yes.
Yes.
Or designated by the Chief Justice.
Yes, 6.
Where is that?
That's 6B, 6B, my lord, at 6B, no? Yes, 6B.
6B?
6, my lord, kindly see 6, 5, 11, subsection 6, my lord.
has been changed.
Yes,
Oh, yes, yes.
yes. So the same power has been given to the High
Okay.
Court. So hopefully, my lord, these sort of clues will help Lordship to
It has not helped. That question is still,
it's
it's still very
lingering
grey.
in the mind. It's the question is lingering in the mind. But the thing is that, my lord, ultimately, it's a larger issue where
There's
we
still
have
no light at the end of the tunnel.
so at the end, my lord, what we have to see is that so far as all other aspects are concerned, there are authorities which have been. But 29A extension of mandate, etc. And your lordship has seen in
You mean
Delhi
to say
High Court.
there's no question of two possible views.
Two possibilities, only one possibility has to. And in Delhi, your lordship has seen that now in the judgment of Justice Jyoti Singh, it is there that all applications under 29A, whether High Court has pecuniary jurisdiction or no pecuniary jurisdiction, are being filed in Delhi High Court, my lord. And those are as a matter of
Delhi High Court is a very special High Court.
High Court.
They have they set a trend in every
No, but
especially comes
now
to
what has happened,
arbitration,
my lord?
patents. They set a trend. So for regarding usurping
Usurping the power of
jurisdiction,
other-
even yes, regarding arbitration, even a plane flies over Delhi, like they'll usurp jurisdiction. So
Like in Calcutta,
that's different.
interim orders were being passed. In Calcutta, Dunlop, you said that even crows flies from that in
Yeah.
Dunlop matter. So therefore, my lord, in the pecuniary, without pecuniary jurisdiction also, because there the pecuniary jurisdiction of the High Court is up to 2 crore rupees. And also beyond 2 crore rupees, my lord. Up to 2 crore rupees is the pecuniary jurisdiction of district court. There was no pecuniary jurisdiction. And based on, in my humble submission, on correct interpretation and correct provisions and reading the definition also. Definition cannot be seen in isolation with these words, my lord. This, unless the context otherwise requires, is also part of the definition. We tend to forget that only when we define court means has to be read along with unless the context otherwise. And I have shown your lordship 2 judgments, Whirlpool judgment and then Indian Medical Association judgment, my lord, where the definition was different and the section, same term in management, it was read differently because context required some other interpretation.
Reading down or
Yes, the context required some other definition, and based on this very provision, my lord, it is there, my lord, and because this is a first matter in Meghalaya High Court, my lord, whatever principle is laid down, probably that will be followed in all matters.
for this High Court.
For this High Court. For this High Court. And ultimately it will be examined, it will be taken up to the other High Courts also as a precedent.
If we take the Supreme Court, then there will be a final decision on 29A.
Because, yes, my lord, ultimately...
So you should have to make an order which is eminently appealable. So that's the only thing.
No, this is a short issue.
Yes.
Just if my learned senior has completed his argument, there's just 2 points I just
No,
want
sir,
to
Yes.
rejoinder to then...
Yes.
I'll...
I'll take just a minute.
Yes. Yes, please.
My lord, the judgment of Swadesh Kumar, my learned senior has relied upon, that paragraph 55, the
Yes.
only point my lord has that judgment,
Yes. Yes.
my lord, paragraph 35,
Yes.
I'll be reading from it goes without saying, that is in the 6th line.
Yeah, from the middle,
It
yes.
goes without saying that
Yes.
it goes without saying that if ultimately it is held that the mandate of sole arbitrator is terminated as per section 14(1)(a) of the 1996 Act, and more particularly on the ground that there was undue delay on the part of the arbitrator in concluding the arbitration proceeding. The arbitrator, this is where I am laying the emphasis. The arbitrator has to be substituted and a fresh arbitrator has to be appointed by following the same procedure which was followed earlier while appointing the present sole arbitrator. My lord, in the present case, and as it has been pointed out by Mr. Banerjee also, that in the present case, my lord, the arbitrator has been appointed by the mutual consent of the parties. It is not the case where the High Court has appointed the arbitrator. My lord, a point related to the same, that the section 11 subsection 6 and 29A is linked also on the basis that if it was only on the basis of the appointment power of the court, that the 29A 6 also would 29A application would also lie before the same court. In such a case, my lord, in the case of an international commercial arbitration, the 29A, by the theory of my learned senior, would go before the Supreme Court. That question has still not been answered, my lords, in the rejoinder.
Yes.
So therefore, we are relying, my lords, on the Allahabad High Court judgment. My learned senior.
Very good, yes.
I'm so sorry, my lord. I'm so sorry, my lord.
That's all right.
Opportunity, my lord, to go away a little bit. I'm so sorry, my lord.
No, it's all right. Okay, all right, yes.
My lord,
Yes.
any my lord, particular my lord issues? I don't know, my lord, whether my lord wants me to answer.
Only
my
the
lord.
point is of the substitution. That's the only thing that's troubling the court, like this court expressed earlier. Anyway, you just file your written notes.
Yes, my lord. Will do.
Yes.
My lord, we'll file our written notes. My lord, that substitution, my lord, yes, my lord, we'll file our
You
written
can
notes.
come with any other decisions regarding, any other authorities or just throw some light on that point, with regard vis-a-vis 29A6,
And substitution also.
that's the only thing.
Of course. My lord, substitution, my lord, we've already made a submission, my lord, on that. 14 also, my lord, talks about, my lord, substitution. Section 14 also, my lord, talks about substitution. So, my lord, that is also there.
Will you kindly file the notes within 1 week?
1 week.
After 1 week. We listed after 1 week of filing of bullet points.
Yes.
Grateful, my lord. Grateful, my lord.
Hearing concluded, just a matter of filing of bullet points by the parties. Yes. Yeah, thank you.
I'm grateful. Thank you, my lord.
Yes.
Supplementary 3.
Should we have it tomorrow in that case, my lord, 4 o'clock?
I'll not take my more than, I have jotted down some points, only that.
Tomorrow will be impossible. Court sitting till only
faster.
first half.
First Monday then? Monday, your lordship.
Monday,
Not possible.
Friday?
Friday, your lordship.
Friday, day after tomorrow.
Day after tomorrow.
So court won't be here. This is the thing. That's
Only-
why I said, ask MS Salam,
Witness.
what a date for me.
No, I got it.
She told you.
I got it. Only thing, my lord, I mean,
I don't want to keep this lingering also.
it's all right, your
understand.
lordship.
Lordship.
Now, my lord, things are fresh in the mind, your lordships.
Exactly. I don't want to-
I
I
do not trouble by repeating the
I
code.
don't want to, what do you call it, make a long adjournment also. Now, I don't want to linger this matter. It's
Tomorrow, if you lordship, I don't know, but then tomorrow only faster, my lord.
because there's a full bench, I think, with the chief tomorrow also.
Then it can be Monday. You know. I don't know, yeah.
Whatever- I'm
Senior
here.
friend, I
You don't have
think.
to reply.
I have to reply, my lord. So whatever date is convenient to court, I am ready to argue. Tomorrow,
You have
day
not,
after
you have
tomorrow.
not completed.
No, I have not completed, so that's why. Whenever,
15 minutes not possible.
15 not minute possible. Not
Monday.
Monday will be a bit difficult. I don't know because other matters also there Monday. Problem with this bench has the maximum number of the entire board of the court.
Everything, all burden has fallen to this court.
Yes, ma'am.
So this,
Monday or Tuesday, Lord.
Tuesday, I am different.
Tuesday then?
Tuesday, I am having difficulty. Wednesday, your lordship.
Wednesday then?
Wednesday,
Yes, that's Wednesday is the 20th.
20th.
Okay.
All right.
They probably fixed on 20th. I just want to conclude it.
Yes, I understand. 20th will conclude.
Yes, yes, madam.
Will.
You'll come as partner. Madam.